The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the program. My name is Marty Schenkman, and I'm joined by two great, brilliant practitioners, Jonathan Blotmacher and Abigail O'Connor. The program today is called Core Estate Planning Documents During COVID. And what the goal of this program is to be very, very practical. We want to give you practical ideas of what you as practitioners, whether you're an estate planning attorney, an accountant, a wealth advisor, insurance consultant, what you should be speaking to your clients about changing, reviewing, updating their core documents. We did what might be viewed as a companion program, Jonathan and I, that is also available on the interactive website and on shankmanlaw.com/webinars on more sophisticated planning in terms of estate tax planning. We're not going to talk about that at all today. We're going to go through the core documents that every client, however wealthy or not, has and talk about practical implications. And obviously, in this difficult time that we're in, and hopefully in the near term that will resolve, one of the big issues is how to sign documents given the difficulty of isolation, quarantining, social distancing, and the really antiquated laws that we're dealing with that don't really integrate modern technology into that. So that'll be a part of what we talk about. We're going to also go through all of the core documents and explain not only some general things that you may know that hopefully will be helpful reminders, but some thoughts that the three of us have had about some unique changes to documents and planning that affect everybody. Now, one of the things, and I want to say this up front, it's on slide 3, we've had issues with internet bandwidth. It's nothing that we can control. And what you see on slide 3 is an analysis that shows the whole half of the eastern part of the United States is just overwhelmed with internet usage. And no doubt this is due to inadequate infrastructure for the dramatic rise in remote working in the current environment. So if you have a problem, we apologize. What we've started to do with this webinar, and it's our first, is we're trying to pre-record the webinars and broadcast them at a specific time to eliminate the drain on the system or the taxing of the system by our having to call in as speakers and then you calling in and the system pushing our voices through the system and out to you. So hopefully the recording approach will address that. Any of the programs that you've attended, if there's a problem, we've tried to address them and post re-recordings to make it easier for you. So we have two sponsors today. I'll make a quick pitch on behalf of Interactive Legal. I'm sorry that Interactive didn't have somebody on, but again, we were trying to limit the number of panelists in case that helps the bandwidth. Not sure. We're just trying whatever we can do to cope with the current circumstances. Interactive Legal is a comprehensive estate planning drafting software system. It's really much more than that. As you draft documents, it has drop-down menus that give you a wide range of planning tips and explanations. There's training videos. It does more than just documents. It does memos, cover letters, checklists, and more. And they've also created a series of partnerships with other tech firms that can give you a lot of things that will be helpful in your practice. I've been using Interactive Legal for many years. I don't understand how anyone can practice without document generation software. It's revolutionized what I do, and their contact information is there. Our second sponsor is Peak Trust, and Jonathan, you were going to make a comment or two on behalf of Peak.
Yeah, Peak Trust Company, which used to be known as the Alaska Trust Company, was formed after Alaska adopted a series of laws, including the first domestic asset protection trust legislation in 1987. I've referred over 200 clients to that company, including my own family, and not one of them has left Peak. They are happy to act just as an administrative trustee for very, very low fees. It happens to be run by my brother and my nephew, and I happen to be the director of estate planning there, which gives me an opportunity to talk to lawyers and accountants and others who are thinking about using Peak as a trustee or other fiduciary. Marty, back to you.
I've had my self-settled trust with Peak since 1998. I set it up within 6 months of the statute Jonathan mentioned, I think, being passed, and I've continued to work with them. Now, one of the things that we've tried to do on every webinar is mention a charity. On the last couple, and this one we're mentioning the American Brain Foundation. We've mentioned programs for Wounded Warriors, the American Cancer Society, the Michael J. Fox Foundation, a whole range of different charities. And if you have a favorite charity and want me to try to give them some information and a plug on a future webinar, let me know. The world is in a very difficult place. Charities are certainly no doubt going to suffer because of the economic downcline. So it really behooves all of us, to ourselves personally and as well as encouraging our clients to consider helping charities more so than ever. The American Brain Foundation, its mission is Cure One, Cure All. It is trying to coordinate brain research so that if we can find a cure for one brain disease, say Parkinson's, that no doubt there will be a domino effect of cures for a myriad of other diseases because of the interconnectedness of brain function. The American Brain Foundation has a unique and incredible tie-in. They were originally an arm of the American Academy of Neurology, and they continue a very close relationship with the American Academy of Neurology. So they get direct input on identifying the most promising research projects from the most brilliant neurologists in the world, and that has helped direct their research efforts, which have been incredible. Apropos to our current COVID situation, there's a task force they created that I'm on to try to raise funds and provide research for the impact of COVID. There's, at the time that we're talking now, some indications that COVID also has an impact on cognitive function, as well as neurologic impacts that haven't really been spoken much about, and they're trying to fund research on that. So let's dig in and let's begin. So we all are living in difficult times: stock market decline, economic turmoil. Today, another 4 million Americans applied for unemployment. I think the number is over 26 million. Quarantine is a strain. We don't know what will happen in terms of the new normal, when it will happen, how it will happen. There's talk and fears of a second wave of the virus that may require quarantining again. But right now, what can we do to help clients? Jonathan, we've talked on other webinars, and this is an important point, so maybe you want to comment on clients' mindset and their fears and discomforts of pursuing planning in the current environment, because that's something that hopefully this whole program will help address.
Well, Marty, thank you. There are two aspects of this. One is, I think anybody who is not hiding under a rock knows that we're all prone to contracting a terrible disease and possibly dying. And it's not just the ancient people, it's the young have died, babies have died, teenagers, people in their 20s. It does indicate that if you have a pre-existing condition such as diabetes or heart disease, you're more prone to die from it, but there have been some very healthy people who have died from it. And it spreads very, very quickly. And everybody is worried about that. And people have different views about how much social distancing and other actions they must take to protect themselves and their families. But they have that, and that has to be number one. And we're going to work in how some of the documents that you're going to create or review for your clients relate to that. The other thing that clients have a fear of is financial loss. Back in the late 1980s, when we had a similar, although nowhere near as severe a downturn as we did, I would go to clients and say, hey, George, this is the perfect time to do estate planning because interest rates have fallen and property values have fallen. Give. And I got an absolutely cold shoulder. And I realized it was, even though that might produce a better chance to get assets over to your family with lower taxes, you were going to be left without adequate resources, or at least you feared that. Remember, everybody has to think of himself or herself first. And so we have to take that into account. Marty mentioned that he and I had done a webinar, which is on his website and also on Peak's website, for estate tax planning during this time. But in every one of those suggestions, we've come up with a way in which the client, the person who originally had the property, can get that property back or the benefits of that property back if a need arises. And I won't go through that, but that's something that if you're going to approach a client about estate tax planning, please consider that the client's going to have to be assured that she can get access to those assets in a time of need. Marty, back to you.
So thanks, Jonathan. One of the last bullet point on slide 9, we're going to post on the web console a sample letter that you can hopefully use however it suits in your practice. And what I envision, just to grossly simplify, is 2 broad categories. Many of us may be not busy and may be concerned about getting clients to continue planning during this very difficult time for all the reasons that are obvious. One of the things that I could see some practitioners doing, and it's not only, by no means is it only estate planning attorneys. In fact, to the contrary, in this very difficult time that we're in, I could see financial advisors more so than any of the other practitioners doing this. Clients are no doubt talking, I would hope they would be talking to their wealth advisors and financial planners in the current environment. They may not be talking to their estate planning attorneys because, gee, they have a will, why deal with it? And it's certainly not foremost on their mind. Some clients are more forward and will address estate planning given the risks and uncertainties that are going on, but many will not. I think the vast majority will not. But if you're a wealth advisor or an accountant and a client contacts you, whether it's about the PPP loan program, if you're an accountant, if you're a wealth advisor about reviewing their portfolio and their investment allocation and budget, which all should be done, this is a great opportunity for you in the allied professions to talk to the client about some of the reasons they need to contact their estate planning attorney and revisit their plan. So even if you're not a draftsperson and not an attorney, what we hope to do in this program is give you the background, the information, and some very specific good suggestions of what clients can do so that you can direct clients when appropriate back to their attorney. So one of the concepts or ideas that we've been thinking about is that you could probably do a fairly high-level, quick review in a half an hour with a client of what's in their estate planning core documents, and then if it's necessary or seems reasonable that they should review it with their attorney, encourage them to go back to their attorney. So the sample communication we're going to give is going to give you some ideas on how to do that, and we'll give you some good ideas of what to do. So one of the questions is, and we've all received lots of emails from law firms and others and financial advisors, everybody should have in place key documents. And what many of those emails do is they just really go through the basic core documents that clients should have, like a will and a power of attorney, which everyone on this call, I assume, understands. But what more can we do and what more can we take? Now, obviously, third bullet point, slide 10, is we have to make sure that clients have the necessary documents in place. Many clients won't. And those calls are likely going to be to the accountant or the financial advisor and probably not the attorney, because clients that have not got documents in place or have documents that are 20 years old probably don't have an ongoing relationship with their estate planning attorney. So what we're going to talk about is giving you the tools, last bullet point on slide 10, to build client goodwill, regardless of which profession you're in, by helping discuss with clients what they need. And I think a lot of the emails that I've seen that no doubt are directed towards consumers, but like all of you, I'm on way too many email lists, are saying, gee, make sure you have a will, make sure you have a healthcare proxy and a power of attorney. But what they're not really doing is helping the client understand, is there something I need to change now? If I have an old will or an old power of attorney, is there anything I really need to change now? I don't want to go spend the money. I don't want to venture out given the difficulties and worries of my health in the coronavirus situation. What do I really need to know if I really need to deal with this now? It's not something I want to do. Do I have to? And that's what we're going to try to talk about. So certainly on slide 12, we're all aware that these things need to be reviewed. But let's go a step further. And this is a very important point that, again, wealth advisors, accountants should all mention to clients. Your client may have estate planning documents. Does their mother, does their elderly aunt, Do their kids who are in college and now maybe living at home or sheltering someplace else, do they have documents in place? College-age children, as Jonathan wisely pointed out, many young adults feel that they're immune from this. They're not immune from this, and they need to address it. And how do they need to address it? It may be a very simple power of attorney and healthcare proxy. So if, God forbid, they get sick, their parents can make decisions, or some responsible adult can make decisions for them. So even if your clients have documents, in many cases, the children have nothing, the adult children, and elderly family members who your client may be responsible or caring for may not.
Marty, let me
Sure.
add one other point. If you have a child who's, say, over the age of 18, in almost all states, she can sign a will. You might say, well, it's unimportant. She doesn't have an awful lot of money, and it's going to go to, her parents anyway. Well, that may be true, but I'll tell you one of the problems. If you have to have an administration without a will, in New York at least, and probably in other states, you're going to have to post a bond. And that bond will cost money, and today it's going to be difficult to arrange for that bond. So everybody in the family, once they get to adulthood, and I mean this, age 18, they need to have a will with certain basic things in there so that their executor can act on their behalf, whether there's a claim for something or whether they have to defend something. But in all events, you do not want to have to post a bond. So it's important for the children as well as other family members to have wills, even a short will, a 2 or 3 pager. You can do a 1-page will on Interactive Legal. It takes you about 4 minutes to do the whole thing. But you've got to have that done for your clients, because heaven forbid, if a person or an old person or even a middle-aged person in the family dies without, you're going to wind up having serious problems.
That's a great point. Let me just take a second and elaborate on that. When I say it's very important for our clients' adult children to have documents, it really is. And what Jonathan said is it doesn't have to be the complex, costly work that may have been done for the client themselves. A young adult, college age, may have minimal assets, but you need a power health proxy, as Jonathan said, a will. If you use document generation software, you can generate very simple documents very, very quickly, very inexpensively. Doesn't have to be a big deal. So that is certainly something that should be addressed. Now, slide 13 is something that every practitioner should recommend to clients. It's practical. I want to give credit to Susan Bruno, who's a very bright insurance consultant out of Florida. It was actually her idea that she shared with me. On slide 14, clients should have an emergency envelope together. And maybe we should have always advised people to do this, but I honestly had never really thought of it until now, and she suggested it. Put a photocopy of your health proxy, your living will, your HIPAA release, your medical documents in the envelope. On the back of the envelope or on the front of the envelope, list some emergency contact, just key information, any major known medical conditions. Inside, put a list of any medications, vitamins, supplements that you're taking, and a copy of your health insurance card. If a God forbid happens and you have to get rushed to the hospital, grab the envelope and go. That envelope will be invaluable in terms of what medications you're on. If there's an ambulance that takes you to the hospital, they need to know. So this is a practical step that I had not suggested to clients before, and it's something that you may want to consider. And listen, in the current environment, regardless of billing and actually doing the work, if we can help clients have some peace of mind because they feel they're taking steps to protect themselves, I think that's a real positive. I think one of the struggles that many people have had is we have this horrific virus that has killed now, I think, over 46,000 Americans. And what do we tell people to do? Wash your hands is the main thing. Social distance. I think people are looking for steps to protect themselves and help themselves, and people want to be proactive. So here's a great simple step that costs next to nothing to do and may help some clients. So that's something. Yeah.
Marty, can I interrupt, please?
Sure.
So I've been for years counseling clients on keeping their healthcare documents someplace easy to find, and sometimes I think they need a little bit more discussion as to where in the home to keep it, Because if they're fallen ill, they may not remember or have the energy or remember where they put it, and their family member may be too distraught to remember easily. So where to keep it is critically important. It should not be kept in a file. This emergency list and the healthcare information should be very easy to find, possibly out and near where they keep their keys or their jacket, or I even used to recommend someplace that was kind of funky, like the freezer or something that they would remember that's odd, and go and get it. So just it's important to know where that is, and I've even had clients email me and tell me where they put it so that someone has an idea as to where they have these documents.
Great point.
Now, Abby, I don't know, but in New York, you can have multiple statements of what you want, multiple medical powers of attorney, healthcare proxies, and multiple living wills, which state whether or not you want the plug pulled at a certain point or whatever. And I typically would have the client sign at least 5. One they would leave at home, one they would send to each of their medical people, one to the healthcare holder himself or herself. It's very, very important, because this will come up and you just don't know where it is. But if your medical physician has it, if any other healthcare providers, I've even given one to my dentist just in case. So when I'm taken off and somebody says, does Jonathan have a living will or a healthcare proxy, somebody in the medical field or within the family will have it. It's very, very important. So if Abby, I don't know about Alaska, Marty, I don't know about New Jersey, but if you're permitted to have more than one, they'll each be an original. Go ahead and do that, I think.
So good point. I used to do that, and I think at this stage, electronically, people are pretty comfortable with copies and PDFs of these documents, and I've never had an issue. So what we used to do is we used to do a minimum of 3 originals, if not more. We've changed years ago to doing 1 original, making copies. The other thing we do is we post PDFs into a electronic vault for each client, which we create under ShareFile, and that vault has the ability to get an app on your smartphone, so anyone can download any of their documents, even on a smartphone, and email it or provide it to a medical provider. So we've done all the electronic stuff, but nonetheless, I think creating this emergency envelope is a great service. Now, by the way, many financial advisors store documents in electronic vaults for clients, the estate planning documents. Many law firms do that. One of the things that I was thinking as we were talking, this is actually a great service that we could even do for clients in the current environment, where some of the clients, especially many older ones, or those that had robust offices and don't have a home office with equipment, we can print these documents, create the envelope, and mail it to the client to let them add the medication and other things. So we could print the documents and set this up for them. Let's go on to another point. Now, Abby or Jonathan, do you want to comment just on the importance of reviewing beneficiary designations, especially with the Secure Act? And I suspect very few clients have gotten to it with all that's going on.
Sure.
Marty, go ahead, Abby.
Okay. So in January, I think we all thought that the Secure Act was going to be the most exciting thing that happened in 2020. And I know I was just starting to talk to clients. I had sent out a letter to all my clients that, hey, we had the Secure Act, and please come back in and review your beneficiary designations and your estate plan. And then we all got distracted with the pandemic. So, understandably so. So I think it's a great time to go back. Many clients that when I meet with them the first time, they don't even know who their beneficiaries are. They assume it's the spouse, and then I ask them if they have contingent beneficiaries, and they give me a blank look. So I think it is very important to go back, review the beneficiary designations, and also then talk about whether or not those, especially when you have married couples and you have the contingent beneficiaries being the children outright, which we might have done previously to get the stretch, whether or not it's now appropriate to put those assets or have them payable to trusts for the children after the Secure Act. So I think it is important to go back and make sure the beneficiary designations fit with the overall plan, and that they have actually been changed if you previously advise your clients to change them?
Let me mention that the Secure Act has really caused problems. For example, I have a disabled child. If I make my child a direct beneficiary of an IRA or qualified plan, he is going to be disqualified for the governmental benefits he currently enjoys, like Medicaid. And it's very important for him to have Medicaid because otherwise he could not have any health insurance. So you've got to make sure that you're doing something that's not going to cause other problems. And oh, by the way, even though your client may not have anybody in the family who's currently disabled, they may have one born or through an accident or through a disease have one in the future. Trusts are the most important, loving thing you can get your clients to do. But the Secure Act has made it much more complicated because even though you can still make IRA or qualified plan benefits payable to a trust, as a general rule, they have to be paid out within 10 years and in some case 5 years. So I could have my plan benefits payable to a trust for my son who's disabled, and that would be fine, except number one, for a disabled person, you can get a lifetime stretch still, but the trust has to be in a certain form to do that. So you've got to be aware of that and talk to your clients about it. Number two, and this is very, very important to keep in mind, yes, you could make it payable to a trust and tell a trustee you may apply it. Maybe it's only for supplemental needs. Maybe it's for some other purpose, and that will work. But keep in mind that the tax rates for trusts are greatly compressed. And once the trust gets up to $12,950 of taxable income, it hits the 37% bracket. An individual doesn't get that bracket, even if she's single, until well over $500,000. So you're going to have to carefully weave that, because otherwise you may have problems with family members. You may have spendthrift problems or unwise dissipation. You won't be protecting the assets from the creditors or predators that are out there unless you're careful. And most important, you've got to think about ways in which you can have the individual rates apply rather than those horribly oppressive trust rates.
So let me comment what this all means, all great points in the current environment. We're going to come to how to create, for example, a revocable trust, which is going to be, I think, the answer, a simple will, a holographic will, and a pour over to a revocable trust. The revocable trust can include an accumulation trust or a conduit trust that can be named beneficiary under the Secure Act. So this is going to all tie back. I started with beneficiary designations because for many clients, this is a primary asset. And as Jonathan and Abby explained, it's absolutely critically important that people address this. And as Abby poignantly said, I mean, we all thought this was going to be the big issue that we were going to deal with in 2020. We had no idea what was coming down the pike with COVID. So we need to still address this for clients. When we're talking to clients about, gee, did you update your will? A lot of clients aren't going to see the issue. You know, I have the same spouse, I have the same kids. You know, yeah, I get that the trusts aren't quite what they should be. I don't know that someone's going to update a will to make it better right now with what's going on. But what we just talked about is probably one of the most important things that we need to advise certain, not all, maybe not many, but certain clients need to readdress how their beneficiary designations treat their retirement plans, because the major changes of the Secure Act, and the Secure Act has been completely eclipsed by everything going on in the world today. How do we do it? We're going to talk to you about creating a Rev Trust and getting it signed in the current environment. How do you get the client to change beneficiaries? I think what you need to do for many of our clients, some are going to be tech savvy enough to get on their laptop and go to the website for their plan provider and change a beneficiary. Many clients won't. So the answer may be, which is the middle of slide 17, use a little bit of technology. Get on a web meeting with the client, have them turn control over from their laptop to you if necessary, and help them drive going to the website for their plan provider, help guide them, and maybe they can do the typing and you just guide them by being on the program with them. If they turn screen sharing over to you, you can see what they're typing, you can tell them which buttons to push, and physically walk not physically, I guess electronically, remotely walk the client through what to do. I've never done that before, but in preparing this program, I realized that for a lot of clients, without somebody helping them, which is not going to happen now because no one's coming to their house, using a web meeting and getting control of their screen is the way to do it. And that's a great approach. And it's something that I encourage you all to give some thought to. Now, let's jump into a new topic. And again, I know everyone on this call is familiar with all the core documents. So we know that you know what a power of attorney is, and we know that you know what should be in it. So clearly we want to make sure a client has an existing power. Abby, do you want to mention anything about some of the things before I get into the COVID specific things that are just the common issues that clients need to address?
In the power of attorney, yes. So I think for when I'm advising clients, the first question is, who are you going to name as your agent? And we discuss practical considerations and also just in terms of family dynamics, and is this person capable of handling your affairs, really comes into play when you have clients that have businesses. And I think the powers of attorney, when you have an entrepreneurial client, are even more important and have to be specifically tailored to allow the power holder to either get access to business accounts, or if there's an office manager, at least have some authority over the business and handle the business. Because the last thing you want is an incapacitated client and now nobody has access to the business account and can't make payroll, which I've seen it in the state context, and it's very scary for the family and the employees. The other thing that I think you would want in your power of attorney to make sure that you have, if appropriate, that you have the right gifting options. Most states, I know Alaska now has it, I know Florida has it where I'm licensed as well. If you want your power holder to be able to make gifts, you have to have special provisions, express provisions in there, and you want to be able to set parameters as to what kind of gifts your agent can make, to whom they can make them, for what purposes, whether or not they should be restricted to the annual exclusion amounts, et cetera, et cetera. And in addition, especially since we're talking a lot about revocable trusts, the powers of attorney should address whether or not your agent has the power to change revocable trusts, amend, revoke, change beneficiary designations, essentially allowing the agent to step into the client's role of finishing out the estate plan should the client become incapacitated before they're able to finish funding the revocable trust or changing beneficiaries or whatever else the plan is.
Jonathan, any other thoughts before I get to the couple of COVID specific ideas?
No, Marty, go right ahead.
So one of the other things to keep in mind, and Jonathan mentioned briefly, and I did as well, another webinar that we did on SLATs, DAPs, SPATs, and other techniques for the current environment, because we both feel very strongly that there's a great likelihood that the government will have to raise taxes, including estate taxes, in order to address paying for some of the bailouts that are going on now. So we've encouraged in that other webinar all clients to evaluate very carefully making large transfers to accessible trust. The gift power that Abby mentioned, you may want to have that kind of discussion with a client. You know, it's not only about you being incapacitated, it's about it being difficult for you to get to a bank or something. Even when things start to reopen, some clients are not going to be comfortable going out to banks and brokerage firms to sign documents. But we very well may want clients, and clients may decide to make very large transfers to irrevocable trusts. So having the broad gifting power may be essential in the power of attorney so that somebody can handle this for them if they're uncomfortable going out. One of the other issues that I've seen come up is just what I call stale documents. And I don't think there's really, I don't know that if there's an actual law on it, but I've had problems over the years of practice, decades of practice, where somebody had a really old power of attorney and a bank or somebody was just getting uncomfortable accepting it. Like, is it really valid? Is that really the right agent? Is that really what the person wanted? It's 20 years old. So sometimes if documents are just too old, a freshen up is important just to make them useful. Now, there are a couple of other things that we need to talk about specifically on slide 21 in this this COVID environment. So this is one that I haven't heard anybody talk about that I think is a major issue. And I know I was speaking to Jonathan about it, so after I lay the groundwork, if you want to comment, Jonathan, please do. Many years ago, I used to kind of give in to clients' desires for springing powers of attorney that become effective on disability. And I get the logic of it. Gee, I don't want my kid having access to my checking account. He doesn't need to have access to my checking account unless I'm disabled. And the result was to create springing powers. But the problem in this environment with a springing power, first of all, most medical personnel are overwhelmed. They describe, the situation in hospitals like war zones. And even if the so-called curve is flattening, the pressure, stress, and difficulties that many medical personnel are having is just incredible. Where are you going to get in the current environment the typical mechanism for springing power is to get a letter from one or two physicians. Many of the documents I've seen require two physicians, an attending physician that regularly treats the client, as well as another physician or a psychiatrist and say an internist or something to sign documents that they've examined the patient and the patient can't the principal can't handle their own financial affairs. How are we going to make that happen? We're not. It's completely impractical. So I think one of the most urgent, important things to do, whether you're a wealth advisor or an accountant or an estate planner, is ask the client, do you know if your power of attorney is a springing power? And I would suggest that probably very few clients are going to have a clue what it means, even if they signed it 5 years ago. But if you get a copy of the document, just look at it, even if you're not an attorney, and see if it requires disability before the agent can act. It's going to be pretty easy to spot it. And if you do, that to me is an urgent issue that requires that the re-signing of a new non-springing immediately effective power of attorney may be a priority for the client. And that's something that I think should be on everybody's radar. Jonathan, do you want to comment at all on that or elaborate?
Marty, I think that's a great point. I always used to put in the thing about you had to have a doctor or two doctors, or one client insisted three doctors say that they were suffering from some sort of condition that prevented them from making appropriate financial decisions. But again, you're going to have difficulty even finding it. How are you going to get that person examined? It's very tough. What I did in the latter part of my practice years, I would say to the client, look, we're going to sign this and I'm going to keep it. And when your son or husband or cousin or whoever it is calls and say, hey, Marty is kind of fallen off the map. Is there a power of attorney? I can say yes and send it. That way the client doesn't have to tell people that there's one in which they were named as the agent, but on the other hand, it's right there. And in fact, you might have that held by not just a copy. Again, you can usually have multiple copies of it, not just by the estate planning lawyer, but maybe the religious advisor to the client, and maybe to the accountant, people that are likely to be called in the event that the client is beginning to suffer from some condition. In fact, the client might even say, look, in the event that something happens to me, call Nancy, my CPA, or call George, my estate planning lawyer, or call Phil, my religious leader. And so you can get it that way. But Marty is absolutely right. At this time, having a springing power of attorney that has a condition of having a doctor examine and certify that the person is suffering from some sort of problem is going to be extremely difficult to do. You're not going to want to take that person out. You're almost impossible to get a doctor to come to the home. So it's really something you need to think about and talk to your clients about.
Let me stop for a second and highlight some of the points we've just talked about. We all want to give value to our clients. If we're not busy, we want to get clients to do more work with us, but we really want to help people. That's why we're all in service professions. We all know, everyone on this call, that everybody needs to look at their asset allocation, their beneficiary designations, their estate planning documents, and make sure they're current. We all knew that. But what we're trying to highlight is not just a refresher on some of the key things that we kind of all know, which I think a refresher is helpful, but what we're trying to do in this program is highlight the things that really will help you differentiate a proactive step a client can take now. So one of the things that we talked about was that grab and go envelope. Anyone that doesn't have it should be counseled to do it now. Any advisor, whether you're an insurance salesman, a financial planner, an attorney, everyone can and should be telling clients to do it. It doesn't cost anything, and many of us have the documents and can help print them and send the envelope if the client can't do that. Clearly, we know if there's really bad people named in a document, we got to get clients to update it. Right? If your ex brother-in-law, who you never liked from the get-go, is the agent under your power of attorney, you got to change it. But what we've also talked about,
Marty,
give me 1 second.
Marty,
Let me just finish this point. The Secure Act, for some, not many, but for some clients, is going to be an absolutely critical step we have to counsel people to address now. And on slide 21 is, to me, a fourth point that requires immediate action. A springing power is not viable in the current environment. If we have a client with that, that's one of those circumstances where, yes, client, I know you don't want to deal with this now, but that's really something that you need to be proactive about. I'm sorry, Jonathan. Back to you.
Well, that's okay. I just want to make 2 points. Number one, if you want to build goodwill with your client, suppose you call your clients and say, look, for any of your children who aren't married, we are willing to do a will, power of attorney, healthcare proxy, and living will for them without charge. Abby, do you think you'd be building goodwill with your clients if you made that call?
Most definitely.
And again, if you have document assembly software, you can do that and even if the person has 3 kids, you can probably get it done in under a half an hour. And it would just be great to really have your client appreciate how much you care about her and her family. That's very, very important. The other thing is about naming in-laws. I've had in-laws that I've been very close to. But Marty, tell me, what is the difference between an in-law and an outlaw?
Not sure.
Outlaws are wanted, Marty.
Okay.
Yes, outlaws are wanted. I hesitate, I shriek when someone says, look, my son-in-law is a partner at Goldman Sachs. My daughter-in-law happens to be a managing director at JP Morgan, or whatever it happens to be. You do not want to name in-laws. You can authorize them to be hired as independent advisors to the fiduciary. Don't name them because of the high rates of divorce. And remember, not every bad marriage winds up in divorce. And, over half of them, it happens that way. So please be cautious when, the guy says, well, my daughter-in-law, my son-in-law, my grandson-in-law, whatever, get them in another way so they aren't in there, personally, and they're not in a position to harm family members, because when you go through a divorce, it is not a logical decision that will be made. It will be a purely emotional one, and often one where they're seeking revenge against the other person who happens to be your client's relative, like a daughter and her husband. So be very, very cautious. I'm just telling you, I've seen very bad things happen when in-laws are named.
Let's go back to slide 21 and the last point. Now, this is something that I think is really important for healthcare documents, and we're going to talk about it. I'm just going to mention it briefly here, but we're going to elaborate on it in the healthcare documents. Is it possible, practical, feasible? Will the agent go to the bank, the brokerage firm, or wherever to physically sign a document and make a decision? Will the bank physically be open? One of the banks that we deal with only has appointments. You can only get in by appointment. Otherwise, it's a drive-through window. Another bank we deal with has closed the branch that we used and consolidated efforts someplace else. What about authorizing the agent to sign documents using e-signature and holding harmless any bank or third party that relies on that? Just give some thought to that for the current environment, and we're going to talk more about that in the next set of documents. Let's go on to the next set of documents. Let's talk about living wills or DNRs. Now, what I'd like to do is let Abby chat with you about some of the general things that you need to know, and then I'm going to cover a COVID-specific couple of issues that need to be addressed. Abby, why don't you talk about the importance of living wills and some of the things that people may want to look at in reviewing them with clients now?
With living wills, Marty, when I'm talking to my clients about it, sometimes they're a little uneasy about making the decisions, and they just don't want to face those choices now. And they just want to leave it up to their kids. And what I counsel them is that's a pretty big burden to put on your children. If something's happening, if you are in a terminal condition and they're not sure what to do, or they're arguing about it, or they're feeling very guilty about it, that's a pretty big burden for them to bear without knowing what your wishes are. So I do encourage my clients to make their wishes known, whether or not they want to have life-sustaining things go on, or if they don't want life-sustaining measures taken. I still encourage them to have it written down in a document, in a living will, so that it's very clear as to what they would want. And I think that will help bring their family comfort in what's going to be a very, very critical and difficult time. That's the living will portion. Marty, I think you're doing healthcare proxy or healthcare power of attorney separately.
Yeah,
but that's
right.
Yeah, that's the biggest point of the living will.
Okay, so living wills, one of the things that I've seen as a major issue is on the top of slide 24, and this is something that may have changed from when the client originally did the document. If you have a client that signed a living will 10 or 15 years ago, have their religious affiliations, involvements, or feelings changed? 5 weeks staying at home quarantined with loved ones having struggled through a horrific illness, and loved ones having died from this illness may very well have people reassess their religious feelings. There may be fundamental changes because of this difficult, tragic time that we're going through that may have people changing what they do or don't want in their documents. I didn't even have that on the screen. It just dawned on me now. That could be absolutely monumental for some clients. Have you had major changes in how you feel about these decisions with what you lived through? So anybody that's had a family member or somebody close to them that has died from this horrific virus, or especially if they've had somebody in their home living through the virus and seen how they've struggled or suffered, may want to change some of their provisions. So that's something to think about. But I think there's a couple of points in living wills and DNRs that really need to be addressed very specifically in light of the COVID environment that we're in. We all know that there have been major worries around the country in terms of the number of ventilators available, talk of rationing ventilators. That's because, quite obviously, and I'm stating the obvious, that one of the major issues that people have had when they've contracted COVID is breathing, and they've had to intubate large numbers of people in order to help them survive and try to get through this period. Many clients, especially
Marty.
Yeah.
Marty, tell people what intubation means, please.
Sure. Intubation means putting a breathing tube that's connected to a breathing machine called a ventilator down into their, help me, Patty, into their trachea. My wife's an anesthesiologist. Into their trachea to help them breathe. And the machine pumps air, oxygen, into their lungs to help them breathe. Now, if you have a mandate in the living will, I do not want to be intubated no matter what, if that document is provided to the medical care providers, why would they intubate you? Why would the nurses and respiratory therapists and other people involved in this process want to expose themselves to potential harm to intubate somebody that doesn't want to be intubated? If there's rationing of ventilators, why would they want to possibly give somebody who said in their living will they don't want to be intubated no matter what, one of the scarce ventilators? Many people sign these documents, and if you Google search living wills, you'll find forms pretty readily that have absolute mandates against intubation. And I'm sure that even lawyer-prepared forms out there may have had that as an option. What did clients have in mind? They had in mind, if I'm in a permanent vegetative state, if I have 2 months to live because I'm in a terminal condition, I don't want to be kept alive artificially with tubes and feeding tubes and ventilators and so on and so forth. That's not what this is right now. Somebody in their 30s, 40s, 50s, 60s, 70s, maybe even 80s, and there was cases of people 100 years old that survived COVID. If you have this virus, Of course you want to be intubated if you don't have something else that's going to kill you within the next month or two, because it's only by intubation in some circumstances that you're going to survive this virus. Clients that have this in their documents need to immediately draft a new document, tear up the old documents, delete them from everywhere so they don't accidentally become the decision that is made. So this is another one of those key action steps where you want to provide a value add and a real help to your client. Take a look with them at their living will or a DNR. If it absolutely blankly prohibits intubation, they really need to change it. What it could say is no intubation if I'm in a terminal condition expected to die within 3 months. No intubation if I'm in a permanent, persistent vegetative state. It should not say no intubation, period. This is a critical issue that, again, I've seen no one talk about that we need to address with our clients. So that's something to me that's absolutely critical, and it's explained on slide 25. Now, let me give another COVID-specific item, and I have 3 on living wills. Each of these is important, and each of these may require an immediate change in the client's living will. And this is not just, they don't like the agent under a power of attorney. These are major fundamental things that we can help clients who may not want to deal with this now identify and change these documents. And I think these kind of issues, clients will be really appreciative if they have them wrong and want to fix them, and we help them, whatever specialty you're in. Top of 26. Now, I'm sorry, bottom of 26. Well, one of the other issues, I would think, and I actually have to go back and look at my document for this, I didn't. If I contract COVID, baby, try any experimental medication that you may have if you think, as the doctors, that this will help get me through this disease. If I'm in really dire straits and there's experimental treatments, go for it. There's no reason not to have that expressly provided for in the documents. Many documents don't. Some documents even provide a different approach to it, of not mandating it. I've lost, hang on one second, folks. Give me a second. All right, I can't find where it is here. It's probably in the healthcare proxy, so we'll talk about that. Now, Avi O'Connor came up with a very clever idea, because one of the things that we're struggling with is, okay, let's say you agree, I want experimental treatment, I want intubation for COVID, but it's too hard to change the documents. What if you can't even get to a notary and state law requires this be notarized or witnessed? What do? Avi, why don't you explain the form that you created on slide 27, 28, and 29 that we're giving everybody here, and how you think it may work?
Sure, Marty. Marty had been raising these excellent points about COVID-19, and I wanted to offer them to clients, but I was aware of a couple things. One is I have several clients who are not going to want to leave their house and sign another document. And in Alaska, we have really strict requirements about signing healthcare directives. And so I knew that wasn't going to be possible for everybody. Also, they've really thought through their choices, and I didn't want them to have to feel like they were redoing something that they already did. But I wanted to be able to address these critical issues if they do get COVID-19 or frankly any coronavirus. So I thought of creating this supplement that is basically a plug-in, and it says to the effect of, regardless of what I have said previously in my healthcare directive, if I have coronavirus, this is what I want, and make it very clear, very to the point, so that it's easy to interpret for healthcare providers. Because Marty raised a great point, and that is that if your healthcare document, if your living will absolutely prohibits intubation, you don't want to miss the ventilator. Well, our Alaska documents, we don't have that express prohibition, and we have these if-then statements, which if you sit there and read it, you can understand it. I did not want clients to have to be subject to having this debated if we're in a mess where we've got tons of cases and the ER is full and the doctors are slammed. didn't want them to have to be where the doctors have to stand and stop and read and interpret a document. Let's just make it very clear, very easy, very quick. And so came up with this idea of this supplement that if they can get to a notary, or if they can have the required witnesses, would actually technically be signed in conformance with Alaska law for advanced healthcare directives. And even if not, includes a clause at the end that says, I can't get to somebody to sign this in front of a notary. However, I'm asking the healthcare provider and the courts to interpret this as if it had the full effect of a healthcare directive. And it goes through things like Marty's brought up, which is the experimental drugs, the ventilator. I added in there that you could be considered for a trial because some of the places, states are running trials. Also have in there things about quarantine. I'm consenting to be quarantined in a hospital, but if I can be quarantined at home, I'd rather do that. Also consenting to having visitors. You know, I'm aware that those who are in quarantine in a hospital, especially end of life, sometimes they are allowed to have visitors, or they're allowed to have people on FaceTime and through tablets and technology. And so this way the hospital's not worrying, well, you know, do you have your consent to have your child in here, or this person in here, or that person in there? We can just put it in exactly who they want to be able to see. And that's on slide 27, that's the last bullet. And also just consent to testing, which this way it's done. It's very easy. Marty, could you please advance to the next slide? The first tab is so the first bullet is the intubation and any medication, and the trials are in here. Also, one of the things that Marty's brought up previously is wanting your agent to be able to communicate electronically, because your agent may not be able to be in the hospital. Either one, you know, they may have COVID-19. They may just geographically not be near the client and not be able to travel. Alaska has incredible travel restrictions. We can't even travel within our own state. We're not supposed to go to another community. So, I mean, there are some exceptions, but generally speaking, they don't want us even leaving our town. So we have all these things. And then I've got this last bullet on this one, where if there's any conflict between what I've already signed and this supplemental document, then I want this supplement to apply, because that's the whole point of this. And then on the last one is the top bullet there. I said, okay, well, this is a developing issue, and there's all sorts of new things coming up. So the top bullet is this catch-all of, I give my agent the authority to consent on my behalf to any additional precautionary measures, treatments, communications, provisions, routines, arrangements, the laundry list of anything else that comes up that might help me. I want them to be able to do that I can't even contemplate now. And then the last bullet is if the statement that if I'm unable to comply with the execution requirements for the document, I'm asking that it be interpreted as the document, and hopefully it works. And counseling clients that this may not work, but it's better than not having anything, and at least it expresses your intent. And so that was what I thought might be helpful.
Thank you, Abby. So again, just to summarize, in this last section, we highlighted a number of points, but critical among them, besides all the general things everyone on the call knows, intubation, experimental medical treatment, you want to make sure that clients don't have documents that contradict what they really want to happen in this environment. And I think clients that don't want to deal with this, which is probably all clients, most clients don't, if you can show them these major issues that they may want to change, I think they'll be incredibly grateful. And that's the kind of goodwill and help that we want to give. So let's change gears and get on to another set of documents. And I lumped together here, or grouped together, healthcare proxies and HIPAA releases. healthcare proxy, as you all know, is a document in which you appoint an agent to make medical decisions. It could be called a medical power of attorney. And a HIPAA release, Health Insurance Portability and Accountability Act, is a document in which you designate an agent and authorize an agent to see PHI, personal or private health information, and to communicate with your physician, see your medical chart. And I've grouped these because both of these involve appointing an agent to either make medical decisions or, in the lesser sense of the HIPAA release, to access medical records. Now, just very quickly, because everyone on this call will know, obviously, if the documents are really old, you want to update them. If they don't have them, you absolutely want to encourage clients to get these documents in place. Everybody should have them. And as Jonathan and I pointed out earlier, in the context of a power and a will, healthcare proxy is one of those critical, vital documents even adult children should have. And again, as I said earlier, just to repeat, because it's so important, if clients have family members, such as a parent, relative, etc., that they are caring for or responsible for or concerned about, they should make sure they have documents. But let's jump in and just focus more quickly on what some of the issues are with health proxies and HIPAA releases unique to this environment. I think on slide 32, here's a major COVID environment change that I have never dealt with before. I haven't seen anyone talk about, and I think for going forward in the future is something we all want to deal with in our forms, in our documents, in our planning for clients. The world is changing. You know, many of us never imagined working remotely, and a lot of us are discovering that, you know, it's not so bad and we can actually function pretty well working remotely. And everything is going to change and be more technologically oriented, more remote, more less face-to-face in the new normal. And that, I think, will extend well beyond when COVID is eventually there's a vaccine and we're all back to whatever the then new normal is. I think a lot of the ways we function will change. But here's specifically what I think is so critical about health proxies and HIPAA releases, and I'm giving you sample language that I created to address it. In the past, if a client's agent went to the hospital to make medical decisions, they would go to the hospital. They would consult with the medical physicians and other medical advisors in the hospital. They would make a decision. They'd often have to sign some paperwork the hospital gave them, and that decision would be carried out. That's not happening now. First of all, with the contagious nature of COVID, nobody's getting into a hospital other than as a patient or a healthcare worker. They're not letting an agent in. They rarely seem to even be able, because of all the worries, to let in a family member for somebody that's dying. So they're certainly not going to let an agent in to discuss healthcare decisions. And the agents are not going to want to go to the hospital because of travel restrictions or their worries about the contagious nature of the disease the virus that they may catch. So what does that mean? Instead of the agent being there physically and signing documents, it's not going to happen. I don't think I've seen any health proxies or HIPAA releases that address remote authorization. We need to do that. We need to authorize the medical providers to accept directions or decisions by the healthcare agent given remotely, such as by Skype, FaceTime, or anything else. We need to authorize them to accept an electronic signature. And what we need to do is not only authorize that, but it's the latter part of the sample language on the bottom of 32. We need to also hold them harmless for accepting decision-making in that capacity. To me, this is one of the additional urgent, significant changes that will warrant a client signing a new health proxy or HIPAA release in the current environment. Yeah, obviously, if they name the ex-brother-in-law or an ex-spouse and they have no one else as agent, they got to update it. You all knew that before this call. But I need us all to rethink the mechanisms for communication because the traditional approaches won't work. Abby, Jonathan, any comments?
So yes, Marty, I put this in the plugin, not the language that you have, which is much better than I put in, but I would suggest if you're going to try to do some kind of an addendum or anything, I think this language is excellent.
Jonathan, any comments before we go on to wills and rev trusts?
No, Marty, go ahead. This is, by the way, I must say this has been great. I am learning a lot. Very, very important stuff, especially today.
What I'm going to do, which I just thought of, and I've been taking notes as we're going through this, I am going to create a checklist of the really hot button items that we're covering in this program, and I'll attach that as a checklist for advisors onto the where we save this on the web console, and when we post it to Schenkman Law Interactive websites, I'm going to give you a checklist that could be one page that any advisor could use when they run through the documents with the clients. I'm not going to go through the ex-brother-in-law or ex-spouse as an agent or something, because you all know that. Just the COVID or unique thoughts that are new to this environment, so that everybody has a simple, practical checklist when they run through this stuff with clients. I think this will be an incredible value add to the clients. And I'm going to add KID documents that we talked about too. Now, let's talk about wills and rev trusts. Abby, I'm going to let you talk for a minute or two on just generally things that need to be addressed in wills and rev trusts. Don't go into the signing issues, because that's coming up next after we get through the documents.
The basic issues that need to be in any will or rev trust are, number one, appointment of a fiduciary, which I now have a separate memo that I send to clients about fiduciary selection and how important it is, because I tell them no matter how great of an estate plan we may write, if you pick a fiduciary who ultimately does a bad job, it can be very difficult to recover. So that's, in my view, the most important choice that the client will make, is who they pick as their fiduciary. The second is to have full dispositive arrangements in the document, so that you've accounted for all the assets and all the beneficiaries who the client wants to take care of. So those are the two biggest items, I think. And then, of course, all the administrative provisions and powers, and those are important, and any tax provisions that you need in there. So those are the key things that I look at, Marty.
Great. Jonathan, any other comments or thoughts?
Oh, go ahead, Marty. I mean, this is all so important.
So I think on slide 35, again, just like we've tried to emphasize, what's really important is to help clients discern, what do I really need to do now? I don't want to deal with this. Or what do I really need to do now? I'm afraid to leave my house. And we're going to spend some significant time in a few minutes and dig into how we as practitioners can actually get this stuff signed. Because the first step, which is what we've been doing, is what do clients really need to change? And we've tried to especially highlight stuff that may have been off radar for many of us. And then we're going to talk about how you actually have to do it. Because let's say the client's got the wrong people named in their will, how do we get it signed? And one of the things we're going to talk about is holographic wills. We're going to talk about some of the emergency legislation in different states. And just so you all know, Jonathan, Abby, I, and a number of other practitioners around the country are now working on an article which hopefully in a week or two should be published in Lineberg Information Services on how to deal with signing documents in the current environment. And that'll be a much more in-depth discussion than what we're going to do now. So you certainly want to go look for that article. If you're not a subscriber to Lineberg, well, you should be. So Jonathan.
Marty.
Yeah.
Marty, let me say one thing about revocable trusts. Powers of attorney are really terrific, but in many, many states, you have great hesitation in getting them respected. I once worked for a firm, and I gave a power of attorney to one of the partners who was going upstate New York to see his mother so he could come back and take care of her banking needs. And I took the form. It was a standard form. He took it up. He had his mother sign it, and he brought it back, and I took it down to the branch of the Chase Manhattan Bank in the building at 1 Chase Manhattan Plaza in downtown Manhattan. And the person at that branch said, "We don't respect this kind of power of attorney." And I said, "Why not?" He said, "Because your firm told us not to." Well, needless to say, that caused just horrible things happening. Fortunately, the woman wasn't near death, but it made it very much more difficult and more expensive. One of the things I began to do was, in the revocable trust, have some person who could take over as a trustee and they could actually change the terms of the document. So if your client has or is going to do a revocable trust and the client might become incompetent and you need a change either for property purposes or tax purposes, allow that independent person to make changes, because that will be respected by the IRS and the court if those changes are made prior to the client's death. If you've got a client who's ill with a will, it becomes nearly impossible for changes to be made. And I went through that. I won't bore you with the story, but I went through that once where the client had a charitable remainder trust, which violated a new condition the IRS required. And it was just horrible. One of the partners of the firm went down and sat at the woman's deathbed for 5 days until he alleged she instructed him to sign her name. Now, we did get it admitted, but it would have been so much easier if she just had a revocable trust with someone who could make any change deemed appropriate. So keep that in mind, and perhaps you want to put that in your revocable trust in addition to a power of attorney. But if you have the revocable trust fully funded with just about everything, and you need a change to be made, like, for example, for these changes in the Secure Act, you can do it. One other thing I might mention about the Secure Act, you might want a standalone qualified plan and IRA trust. You don't have to do that, but if you have one, you know what the terms are. It's easy to look at. It will be revocable by your client, so it can be changed. And I would suggest you consider doing that. By the way, in ILS, we do have such a separate standalone qualified plan IRA trust. That's really something I think important to consider.
Thank you, Jonathan. You know what? Let me just add to that comment, and I kind of rushed through wills and rev trust to get to the signing issues. At this juncture, I don't know that I would ever want to prepare documents in terms of just a simple standard will and not use a pour over will and rev trust. The advantages of a revocable trust are dramatically more than addressing probate avoidance, providing and helping clients as they age or if they have health or disability issues. A revocable trust is absolutely superior in all senses to a power of attorney. By assigning a tax ID number to a revocable trust, you have the ability to perhaps minimize some of the damage from identity theft because assets are in a different name and different tax ID number. Banks and trust companies are very loath, and very few will accept being an agent under power for clients that don't have somebody to name, whereas they will be a trustee under a revocable trust. And now with this COVID issue, handling things remotely, if they're already pre-transferred to the revocable trust, it's funded, it's going to be a lot easier than using a power of attorney, because an agent is not going to feasibly necessarily and certainly not easily get to a bank or brokerage firm and get something transacted. So it certainly seems that a revocable trust has many advantages that need to really be considered. But what really pushed me to the edge is what we're going to talk about next, is what do you do to get documents signed in the current environment? And it seems to me that if you have a fully funded revocable trust, and a revocable trust in many states will require, not all, I think Florida is different, will require much less formality to amend and restate than a will require to sign a new will. You just are giving more flexibility to be able to help a client in difficult times. So I think we all need as a profession to really reassess whether we should ever use a standard will versus a pour over will and revocable trust. Jonathan or Abby, do you want to comment on what I just said?
Well, Marty, let me say one thing. I mentioned that I wrote an article about using the rev trust in a way that you could make changes and do other things, preserve losses, and so on and so forth. I wrote that up in the 1989 University of Miami, now Heckerling Institute. And it's called simply the Master Living Trust. And Marty, why don't I send you a copy of that article, and then you can direct people to your website so they can download it if they'd like to read it. I thought it was a very good idea, and I have consistently had those provisions in revocable trusts that I created all the time for clients.
Sounds great. All right, let's get into what I think is going to be the most challenging of things to do for us. And this is something that it's not really what we're going to discuss with clients, but rather we're going to have to advise clients on what to do. Abby, you want to talk about the environment and the issues in a broad sense of what we're facing and why. And if you want to use Alaska as an illustration, you can.
Sure, Marty. What we're facing now is an array of clients, some of whom are in quarantine because maybe they've traveled or they've been told to be in quarantine, or they're ill, or they're staying at home because they're high risk and they don't want to have contact with people outside, or they're just obeying stay-at-home orders. All sorts of reasons why clients right now cannot get to your office or don't want to come to your office. And we have, all wills all have some kind of a execution requirement. And so how do we deal with them when the client is effectively stuck at home and we can't get to them, or maybe we can, but in an unconventional way? And how do we get the documents signed? And this does not just apply to wills. This applies to powers of attorney, to the healthcare documents, and this whole basic suite of documents.
Thanks, Abby. So the challenge is, what do we do? Now, clients are just going to want to hear the answer. Everything else we've talked about up until now are things we have to interact with the clients about and determine what their wishes are. Here we have to come up with answers. Now, some of the things that you may consider: if there's a trust that needs to be changed, can the trust protector do it? One of the things that we had with a client with a revocable trust is certain actions that we needed to take required that the actions be acknowledged by a notary. But what we figured out, and actually I'll give Ed Morrow credit, he figured it out because I hadn't even thought of it, and it was a clever sort of out-of-the-box idea. We were able to have the trust protector modify the revocable trust to eliminate the need for the actions we had to take to be notarized, and we were able to do that. And it was successful, and the bank accepted it, and we moved on. So think out of the box and see what it is you can do, and it's going to be tough. Jonathan, on slide 38, one of the issues that we talk about, and I don't think we really have time to go through some of the different acts and things like that, but why don't you take a second and talk about this idea of line of sight or physical presence and what that really means? Because that'll be relevant, which we'll cover in a few minutes, the concept of, through the looking glass.
Yeah, this is an important issue. And in fact, right after the coronavirus stuff happened, and I was basically a shut-in at our home with my wife, I needed to sign a new will. And in New York, you have to have line of sight and/or physical presence. In other words, you have to actually see. So I came up with a couple of ideas. One is, if you had a client that just can't be seen physically, maybe she's in a nursing home, she's afraid to come out, you're afraid to come in, or maybe there's an order that neither of those can happen, you could have her go to the window. And you can have her listen in on a cell phone or maybe through the glass, and you do the same outside. You have your witness, and you say, Muriel, and you are going to slip the proposed will under, the mail drop slot in the door for the nursing home or at her home, or you'll mail it to her, but you'll be there and she'll have the original, and then you can go through the formalities of execution. And that will be line of sight, and I think it constitutes physical presence. I don't think because you happen to have a piece of glass between you and the testator, it's going to say that the will is not valid. I had to do my own will, as I said, and what I did is I called up our next door neighbors, and I said, look, I'm going to come to the end of your walkway up to your front door, and I'm going to call you when I'm there. Please come out. I'm going to walk halfway. The walkway is about 80 feet. I'm going to come up halfway. You will actually see me, and I will declare this instrument to be my last will and testament. You'll see me sign it, and I'm going to ask you two to act as witnesses and sign your names and put your printed name and your physical address there. So we did that. I called them. They came out on their stoop. I walked up. I held up the instrument. They saw me sign it. I said, this is my last will and testament. I'm asking you two to act as witnesses. And then I put it down, and they walked halfway down where the will was. They picked it up. Everybody's wearing gloves, of course, and they signed it, and then they dropped it and put it down, and they went back to their stoop, and I went and picked it up. So it can be done. And I think, Abby, you've done something similar to that in your own garage, correct?
I did, Jonathan. So I had a client who, and this was earlier when our mandates were first out. I had a client who needed to sign a will, did not want to do a trust. We had already drafted the will. Everything was ready to be signed. And then she just got delayed. And then we had this pandemic hit. So what she did is she wanted to get out of the house and stay in her car. She was tired of being shut in. So she drove to my driveway, because I have a fairly nice sized driveway, and I had emailed her the will ahead of time, and I printed out the witness page. So she printed out the will, everything, all the pages that she had to initial, and she's an attorney, so she's very sophisticated in terms of what requirements are, and she respects them. So she printed out the will, she printed out her signature page, I printed out the witness page, and she pulled into the driveway. It was snowing, which added a little bit of flavor to this, and she opened her car door. My husband and I stood outside the car at a safe distance. We watched her sign her will, and she initialed each page. She signed at the end, and then she had those were the pages that she had printed. She put them in a box that I had in the garage, and then my husband and I signed the witness page, which I had pre-printed, and I put them in the box. And then, I handled notarizing her other documents the same way. And then I waited until it was safe, at least 24 hours, and assembled all of the documents. And so we didn't use gloves, because we never touched the same papers, and we never got within probably 10 feet of each other, if not more. And it worked great.
Let me mention, someone might be thinking, well, Jonathan, since you're such a fan of revocable trust, why did you need to sign a new will? And the reason is because there's a small trust for my benefit under my father's will, but he was one of the leading trust and estates lawyers in the country, that I had to execute that by my own will. Today, people put it in that you can do it by any document delivered to the trustee. But my father died in 1972. His will was done in 1970. And in those old days, people always said, you got to execute it by a will as opposed to a lifetime instrument. So I needed to do that. The other reason was I created a trust, Betsy created a trust for my benefit, and I wanted to exercise that power back in her favor. Now, she did that in 2011, and we wanted to make sure they were not reciprocal, so-called spousal lifetime access trusts. But she could not, and I could not, have a power of appointment to prevent the trust from being a grantor trust with respect to her, unless the power could only be exercised by will. Under Section 674 of the Code, if anybody other than a completely adverse party has a power to control any of the beneficial enjoyment of the property under the instrument, there are exceptions for independent trustees and some others, but one of the exceptions is for a testamentary power of appointment. Now, these rules were written, the grantor trust rules were written originally in the 1940s, adopted almost completely in the 1954 Code, and continue that way. But the exception is when it's going to affect something after the death of the grantor or the grantor's spouse, it has to be by a will. You can't do it by a rev trust. Now, again, this was done so long ago, nobody was using concepts of executing powers of attorney by something other than a will. So you may draft one, and you're going to have the same problem that I had. I had to execute this power back in Betsy's favor by a will. I couldn't do it by any other thing. Otherwise, it would have caused it to be a grantor trust, which we did not want it to be a grantor trust because we didn't want to have to pay New York State income taxes on certain property. So I just want you to know that that's sometimes the extra step you have to take.
So on slide 39, I'll tell you an approach that we've used. Elderly client needed to sign documents. We needed to maintain separateness. So the documents were prepared, printed. They were mailed to her so she could review them. We confirmed that, documented that, went to her house, put the final signing documents in an envelope, left them inside the screen door. She opened the door when we got away from the porch, took the documents, wearing gloves, went inside, went to her living room picture window, sat down by the bench by the window, called us on the cell phone, had it on speaker, witness and notary outside, standing 6 feet apart, watching her sign it through the window while hearing her on the cell phone so we could ask her questions, converse with her. She declared it to be her will, et cetera, et cetera, et cetera. When she finished, she put it back in the envelope, left it in the screen door. We went up, fetched the envelope, and each of us witnessed it using sort of the approach that Jonathan said. So again, these are some of the sort of creative approaches. I've heard of the drive-by signing where somebody comes in their car to the lawyer office and they wear gloves and they'll sign the document in front of the lawyer, then leave it on a table or on the hood of the car, get back in the car, the lawyer will go and sign and go through it that way. So these are some of the ways that we've addressed these problems. The frustration that I think we all have is we want to help clients, we want to do it safely for the clients, safely for us, and the law just isn't there and doesn't really permit it. My hope is that one of the positives that will come out of this very challenging and sad time is that we will actually revise all of the rules and accept real electronic documents. Many states have enacted emergency measures, and we have materials on some of them. If they're not current, let me know, and we'll update them. But the emergency measures are still rooted for most parts in the construct of a paper document. So for example, New York's emergency measures, which we have slides on later, but we have about 15 minutes left. We're not going to get through all that detail, but we've given you the materials. Requires for a remote notarization. It's only during this period of an emergency, so it's a very finite, limited time. And that really doesn't help much either, because what if there's a resurgence and we have this issue? It also doesn't really help much because when the emergency ends, it doesn't mean clients are going to be comfortable going out and signing a document where social distancing is a challenge. So we really need much more than these temporary emergency measures. But the New York concept, just as an example, if I'm understanding it correctly, is the client has to sign the documents, let's say at their home, and then either fax them to the notary or scan them and email them to the notary, who has to then print them and sign them, rescan them, or fax them back to the client. Now, I don't understand the need for any of that, because if you use a recorded web meeting, you can confirm all of that without the back and forth. The practicality of that is very worrisome. How many clients have scanners or fax machines at home? I would take a guess that most don't. And even the clients that may have something, if you have a 50-page will, are they really going to be able to manipulate that? Now, you can get an app for free on your smartphone to use your camera on your phone to take a picture that turns the picture into PDF, and then you can email the PDF. Now, that's wonderful, but if you got a 30, 40-page will, is the client going to really be able to photograph it and send each of those pages? I think it's just not practical. At any rate, here's a solution that may work for some of you, and it'll depend on state law. So, for example, this works in New Jersey, seems to work in Alaska. New York, it really won't work because it's very limited. But here's the approach. I can, and this is just the top bullet point, I can sign a holographic will in New Jersey or Alaska, but not New York. That holographic will can say, I hereby name Abigail O'Connor as my personal representative. I void any prior wills, revoke any prior wills. Abby shall serve without bond. I pour all assets into the Martin Shankman Revocable Trust, and I sign it. Now, if I do that in my handwriting and I sign it, that should be a valid holographic will. And I believe we may have a sample here. If not, we'll have it somewhere for you. And then I pour it into a Rev Trust. That may work. And a Rev Trust can have, obviously, in many states, much less, not Florida, I believe, but much less rigid requirements for valid execution. Now, there's another concept that New Jersey law permits, and there's another state law that may be written up later that permits it, and it may be possible in a number of states, that if you have a valid writing intended as a will, even if it doesn't comply with the statutory requirements for a will, that can be accepted as a will. Now, the downside to that is you may need a court proceeding to get the document accepted, but the upside is a client can sign a document, state they intend this to be their will, and they just can't, because of COVID, comply with all the statutory requirements, and that may be another effective way to do it. So the point on slide 40, in some states, but obviously you must review state law, you could possibly use a handwritten holographic will that does a pour over into a rev trust that may be signed with less formalities and make it feasible. Another approach, which may be valid in states other than New Jersey, is a document intended as a will. And frankly, if I were to do a document with a client intended as a will, I would record the entire signing ceremony on a web meeting with the witnesses and notaries present with video cams on, so that's all recorded, and document everything. I'd have that video saved permanently for future reference. And I think you have a great shot at doing that. Now, again, the problem is with some of these documents, if the client can't print or mail paper copies, what do you do? So what I've suggested is on slide 42 is just what I've said here, which is to have the client do a holographic will, print and sign, or we can mail them a revocable trust to sign, and do it in a manner that will comply with state law. Now, Jonathan already explained what I called on slide 43, what I dubbed it the dueling witnesses, in the sense of, in the old pistol duels, each person would march a certain number of steps backwards and so on. So it kind of, as Jonathan described, if you need to witness something with a neighbor, we'll stand 20 feet apart. I'll walk up 10 feet, sign the document, leave it, walk back 10 feet. You walk up 10 feet, bring your own pen, use your gloves, wear a mask if you wish, and sign the document. Now, one of the things I've heard a number of practitioners do, but I want to offer a caveat on the bottom of 43. One of the things I've seen on some of the listservs is a comment that they would put in the document that the client intends to re-sign it. This is just a temporary document during COVID. I would never put that in a document, and I don't think you want to have anything like that except with great caution in a document, because it may suggest that it's not intended to be a permanent document. Another suggestion on one of the listservs, which may make sense, is if you have to do something as an interim measure to get something signed that doesn't comport with current law, then have a letter sent to the client, an email sent to the client saying, hey, we did this as an interim measure. We signed this as a writing intended to be a will, as I described with the McCool case under New Jersey a couple slides ago. But as soon as it is safe and you're comfortable, we should have a more traditional re-execution. That may protect the practitioner and show that you're doing this to help the client, but be careful what you put in. Now on slide 44 and 45, I have a sample of a holographic will. I took a document that Abby prepared and kind of modified it. If you're going to have a client sign a holographic will, I think as a practitioner, you want to type up exactly what you want them to copy. You don't want to dictate it and make it too hard. So keep it short, but type it up and send it to them so they can sign it over. On the bottom, on slide 46, let's say you have something signed while you're recording it on a web meeting, which I think is where the law should go. And Jonathan, after I suggest this, I want to flip it back to you, because we did a mock signing like this, and I think it may be worth your commenting on. But what you could do is have a modification to the witnessing, to the notarization, indicating that you watched and this was done in accordance with in this case, a GoToWebinar, go to meeting, Zoom meeting, whatever it is you use, and clarify in the affidavit how you're handling that. So you should revise the affidavit for the witnesses and everything else, indicating exactly what was done, and that's also talked about on slide 47. Jonathan, in terms of signing a will, we went through with Mitchell Gans, Professor Gans, a mock will signing. And I think I may even have a checklist coming up on what should be done during that. Do you want to comment or talk about that for a minute? Because I think that's the wave of the future, and I think if somebody has to improvise now, I think that may be something that's worth doing.
Well, let me say by background, there is a case in New York where the witnesses listened to the ceremony over a phone. Testator signed, said, I'm signing my will, I'm asking you guys to act as witnesses, and they did that with other pages of the will. The court denied that as being a valid will because the witnesses were not in the line of sight of the testator. However, when Marty, as the testator, and Mitch Gans and I as witnesses did this, and we did it live, we actually were watching Marty over the equivalent of Zoom or Skype or GoToMeeting. We could actually see him. Marty held up the document. In fact, he showed us all the pages. He signed it. He declared it to be his last will and testament, and he asked Mitchell and me to act as witnesses. And under the law of most states, you don't really have to have the testator there. But what could be done if this was for real? Marty would then have that will that he assigned delivered to us. Probably it would be best if it was the same day, but it doesn't have to be. And then Mitchell and I would each sign that instrument as a witness. Marty would be on the line seeing that as well. Now, you know, physical presence, what does it mean? If you see the person sign it over the internet, but in real time, I think that should be accepted. Obviously, unless you have a government order, for example, for an executive order of the governor or temporary legislation, Kentucky has a very, very strong will now, but I think it's only during the coronavirus pandemic. Similarly, Governor Cuomo of New York signed an executive order, but it's only for this period of time. I'm with Marty, and I think Abby's with us. We have to change the procedures. This is a good thing to have. I have serious questions about why we have to be so strict under the statute of wills when most of our property is going to pass by a beneficiary designation or a revocable trust where, except in Florida for a revocable trust, you don't have to have the formalities of a will. But that's a big thing to undertake, but I'm hoping that the lawyers can lead the way and very, very soon to get every state to adopt permanent legislation which will allow people to substantially comply with legislation which doesn't have these strict formalities of physical presence, line of sight, or other things.
And don't forget, everyone, those laws were created long before we had an internet or even laptops. So it's long overdue to try to address it. In the mock will signing ceremony I did with Jonathan and Mitch Gans as my witnesses, I showed my driver's license, and I obviously blocked out some of it with a Post-it note to the screen. So there's a photograph proving photograph ID, and I could show two IDs. I could have shown them a passport as well to prove who I am, and it's all recorded. And as Jonathan said, each page that I initialed on this mock will, I showed that page, and I actually printed out my actual will to do this, to the screen. So you have a permanent record of a screenshot of every page that I initialed. I panned the webcam around the room to show that there was nobody else physically in the room when I was signing, so that we'd have a record of that. I took the web camera and shot a picture outside of the window from where I was sitting. So if we ever had to prove where I was physically located, you have actual photographic evidence of where I was. I stated that I was in my residence in Danbury, Connecticut, and the date, the time, and everything else. And by the way, the date and the time is all recorded on the recording as well. So there's really an incredible array of safeguards that can be integrated in this, because I know that one of the issues that many of our colleagues have had when this has been addressed is it really going to be susceptible to more abuse? And I think with a modicum of precaution and common sense, it really doesn't have to be any riskier and maybe less risky than an actual physical will signing. But but a lot of these emergency measures just don't work because they're still rooted in paper, and you end up with Abby's box in her garage, or me in front of the picture window, or Jonathan doing the dueling witnesses in front of his neighbor's house. Now, on slide 51, I've given you a detailed checklist that I've created from the mock will signing. And Jonathan, I've added much more to this than what we did in our will signing. And I think this may be a model for what could be used. Now, what does that do for you practically today? If I had a client that really wanted to sign documents, it wasn't feasible to do any of the drive-by, garage box, picture window signings, and if the emergency legislation in the state I was in just didn't give me enough wherewithal, I would try this and obviously go on record with the client that I can't guarantee it, but I think there's a lot that could be done. Now, one of the things I've integrated, and you see e-sign is the second bullet point, you can use electronic signatures as well. The law certainly doesn't permit that really yet for a will, although a huge amount of commerce is done that way. Right now, almost all commerce is probably done by e-signing. I don't know why we as lawyers have resisted it, but I think it's time for that too. So I've built into this checklist where you use e-signing some alternate provisions as well. So that's a detailed checklist of what you would do to do a document signing online. Now, even if you mail a document to a client and have them sign it and they have them mail it back and witness, I would still use that checklist to video record using Zoom, GoToMeeting, WebEx, whatever program you have, the stuff. Now, what we have on the next segment, but we're out of time, but I'm going to just leave it for all of you for reference. And as I said, Abby, Jonathan, I, and perhaps 4 or 5 other colleagues are working on an article for Lineberg on this exact issue, is what the different states require and how it is. And we'll just skip through that and wrap up because we're done. But we've listed a number of state laws there, and we'll get much more in the upcoming Lineberg article. On slide 70, 71, I just raised an issue that may happen for some of us. We'll have to give some thought to which state law applies and which state law is going to be designated in the document. If I lived in Connecticut as my permanent residence, but I was in Massachusetts sheltering in place with my children, how do I sign? Which state law governs? Which state law is in the documents? You just want to give some thought to that. Slide 72, I've talked about some financial planning considerations. I think this is an opportune time to encourage all clients to get their finances organized, get some records of what they have, because if any of this is going to happen and work in terms of documents, you want the financial matters in place as well. So a simple point on slide 74, if clients are still paying bills manually, let them get everything done automatically online. Let them get everything charged to credit cards or paid out of their checking account. These are things we can guide clients to do now to eliminate a lot of the paperwork, makes it easier for agents, may eliminate the need for an agent to sign things, because if everything is on auto pay, you don't need an agent to sign documents. I've talked about communications with agents. We're out of time. I'm going to prepare the hot checklist that I mentioned of points for you and post that as well with the website. And let me just have each of Jonathan and then Abby after Jonathan say a last word.
Abby?
Jonathan, did you want to go?
Well, let me just say, Marty, I found that I learned a tremendous amount. This is obviously important. We have a duty to our clients and have to do the best job we can for them. And we have what we have, but there's so much you can do. And I hope people who listen to this found it informative.
Abby?
And I echo Jonathan's remarks. Marty, thank you for putting this together. I learned a lot from helping prepare it and also from giving the presentation and listening to the two of you. And for everybody else, I think this is an opportunity where we can really shine and help our clients in ways that they hadn't anticipated, because none of us had anticipated. So thank you all for your time.
Let me repeat a comment I made earlier, because I think it's really critical. whether you're an attorney, an accountant, a wealth advisor, financial planner, trust officer, insurance consultant, whatever role you play, you need to help clients address this. This is a very emotionally traumatic time. Clients are struggling with physical issues. Clients have lost loved ones. Clients have been sick. Clients are fearful. Whichever advisor has the contact with the client should spearhead addressing these issues, because it doesn't matter who addresses them. What matters is getting the clients taken care of. So if you're an insurance consultant and your client calls you, talk to them about these issues. And if they need to be referred back to their wealth advisor to get some help on beneficiary designations, consolidating assets, getting things on auto pay, or to their accountant whose bookkeeper may help them, if they need to get referred back to the attorney to do a new living will because theirs is detrimental and very wrong for what they want, you spearhead it. It doesn't matter who does it. We should all be proactive and help clients. Thank you for joining us, and do take a look at the other webinar that Jonathan and I did on estate tax planning in the current environment. That may be a companion to this that will be helpful to you. And I want to thank our sponsors, Peak Trust, Interactive Legal, and the charity that we mentioned for this program, the American Brain Foundation. Thank you, everybody. Stay safe.